So, welcome to Monthly Acorns, everyone. I'm Sarah. I'm your alternative host this afternoon. Natalie originally thought she wasn't going to make it, but now she's hanging out with us, so that makes me happy. But anyway, a little background on me: I'm a transactional and entity attorney with Treaty Oak Employers Law Group, and I'm always really happy to work with the great team that Natalie put together. And I'll let everybody else give their introductions in a little bit. So yeah, I work on the business side of employment problems. So think like sales, mergers, ownership changes, transactional documents that you might think in the time they don't really matter, but then they can blow up and bite you in the butt, and then you have to talk to Brian. But I really like my transactional work ankle, and I think that we basically can be a one-stop shop for any problem that might come up with you, and we have a good referral network if we don't. Um, so today's topic is so sorry, I messed up. You can tell I don't host often. So my job on most days is not to litigate employment cases. So it's to find the employment problems before a deal closes or a dispute starts. Hopefully we don't have a situation where someone's like, I already signed this. What do I do now? And what I see from that seat is that legal exposure that ends up in litigation almost always builds up quietly over a long time. It's not like something that might happen that you immediately get a red flag for unless you see it all the time. And through practices that are informal, managers who use their judgment, didn't think it was a big deal, and complaints that were handled in a way they thought they were appropriate at the time, but then it was forgotten about. So today's topic is the mechanism behind all that. So how workplace risk builds through informal practices, manager habits, communication patterns, and things that go unsaid. So by the end of the session, you should understand how the law treats practices that were never really written down, why silence in the face of known problems that you've been alerted to can constitute approval in most cases, and what you can do about that before someone else finds it first and you're in a litigation situation. So at this time, I'm going to let our panel introduce themselves. So Brian, let's go ahead and start with you.
Hi, I'm Brian Levy. I handle the firm's litigation, so I spend most of my time dealing with opposing counsel or a pro se plaintiff. But generally, anytime there's an opposing party, I help out. And I'm happy to do that for you.
Yeah, Lindsay, why don't you go ahead next?
I'm Lindsay Lee, Dr. Lindsay Lee. I should say that more often. I am an organizational psychologist, and the work I do here at the firm, primarily, I am our senior investigator handling our investigative work, as well as providing executive coaching, usually not to the same client, and so that's the primary way I spend my time. But there's also occasional threat assessment work or cultural assessment that I will do when those projects come in. And so I'm kind of I try to also be on the prevention side of the work that we do, and especially through our investigative process, try to really help our clients understand what gave rise to the complaints that they're getting so that they can make some structural changes if needed. And so those are that's the kind of work that really energizes me here at the firm.
Yeah. And last but certainly not least is Amber.
Yeah, so I'm an HR consultant, so I partner with employers on day-to-day HR challenges that quickly can become legal issues if they're not handled well. So everything from employee relations, performance management, leave administration, compliance, handbooks, policies. So just really helping organizations build practical, consistent practices that protect the business and have a better experience for the employees as well.
Awesome. Well, our first segment today, and welcome everyone, is how culture becomes policy. So, most of you came here today probably thinking culture is more of a retention problem or morale problem. And we're going to spend the next hour making the case that it's also a legal problem to have on your radar, and that the law doesn't actually care whether the practice you've been following was intentional. So first, let's go to Brian. Brian, most employers think of workplace risk in terms of specific isolated incidents, a complaint, a termination, a lawsuit. What does the law say about practices and patterns that were never formalized but kept happening consistently over time?
Yeah, so if you don't have a written policy, what will be looked at is what generally happens in that circumstance. So they call it de facto policy or pattern and practice policy. But it's really what happens whether or not you have a written policy on that. And this also comes up where you have a written policy, but that's not how it's actually done in your company. And so you might think it's being done one way when in fact that is absolutely not what's going on. So it's better to know those things and check up on them from time to time.
Yeah, and I'm going to keep picking on you, Brian. So, if there's a manager with a bias influence for a decision made by someone higher up who had no discriminatory intent, how does that work? And why does it matter to a mid-sized company, say 20 people?
Sure. I think what you're talking about is cat's paw liability theory. And that is the case on point is Staub v. Proctor Hospital. But that's not what you need to be focused on about this. Basically, if you have a manager who is biased towards an employee, maybe like writing them up for conduct that is not being addressed when other employees think about you have of your 20 employees, you have 4 or 5 that are regularly pretty late, like maybe once or twice a week. Over the long haul, they're coming in 5 to 10 minutes late, and you only are writing up one employee because this manager doesn't like that employee. Well, then as the owner, all you see is that write up, and so you think, oh, okay, this is a bad employee. I'm going to go ahead and terminate them. And you do that, and then all of a sudden you get a lawsuit. And that employee's attorney is saying that it wasn't that you were biased, owner, when you made the decision to terminate her. It's that you were making a decision on biased information because that supervisor was the one that's biased. So your lack of knowledge is not a defense.
I think that's the right answer, Brian. And Amber, from an HR standpoint, what informal manager habits have you seen that accumulate into legal exposure without anyone really noticing? So the day-to-day discretionary decisions that aren't tracked.
Yeah, absolutely. So a lot of what, Brian said coming to inconsistency, um, and, from an HR perspective, we don't want to take that decision making away from managers. We do want it consistent, but they don't realize they're making a lot of employment decisions every week. So it's not just the hiring and firing, it's every schedule adjustment, performance conversation, exception to a policy, opportunity they give someone, but not someone else. And so, even with good intentions, we need to make sure that we have consistency and documentation and manager training, especially to make sure that we are being very consistent with all of those decisions.
And what I see more often from a transactional perspective is whenever you see like a buy or sale of a business and you're going through the due diligence process, these informal practices are often what comes to light during the buy sale process. So the buyer's counsel, they're going to briefly skim your handbook. Usually they don't even read it that thoroughly, but they're going to be asking your employees how things actually work in the company. And when they get a different answer than what's in your handbook and they start seeing, the disparities, they're going to ask more questions, and it can just make things really messy. So before you have a lawsuit, before you're thinking of selling your company, just get those things ironed out. So now we're going to move to the second segment. So focusing on constructive knowledge, which in other words is just what the employer is deemed to know, even if you're like, hey, I didn't really have explicit knowledge of this. So we've established how informal practices, they can become policy, even if it's different than what you've written down. And now let's talk about the part that it surprises employers the most. So what the law says you knew, even when nobody told you. Brian, what can you go into a bit more detail about what constructive knowledge is and why does it mean an employer can be held responsible for like a supervisor's misconduct, even when no one up the chain even heard about that supervisor's misconduct?
Yeah, to break it down into just simple language, constructive knowledge is not that someone told you, but no one told you, and the matter was visible, pervasive, or discoverable enough that a reasonable employer who paid attention would have known that. So the legal way is knew or should have known. And it's that should have known that really creeps up on employers. And that comes up a lot of times when maybe the practice is pervasive, meaning that it's a regular practice and it's happening all the time. A lot of times owners think, oh, I didn't know about it, so I can't be held liable because of it. And this is where the should have known creeps up, because if you're an absentee owner, it doesn't give you a defense, and you're charged with the knowledge of what a reasonable person would uncover had they done the digging. And juries are not super forgiving in this area.
Yeah. And Amber, what complaint handling failure create these constructive knowledge problems? What do you see an employer do or not do that puts that employer on the hook for something it claims it never knew about?
Absolutely. So I think I'll say the top three that I have, which is, treating concerns like just conversations, and I conversationally talking about it, but never really documenting it. So even if it's a casual conversation, document, document, document. I know I say that a lot, but it's so important. And then stopping after that initial conversation. So there's a concern, but you don't follow up with the employee, you don't follow up with the manager, you don't know if that behavior stopped. Closing the loop is extremely important. And then I think the third thing is managers not looping in the correct people. So whether that's HR, if you have a HR person at your company, or whatever relevant company person that equates at the company, just to make sure they're protected, they're making the right decisions, they're following the correct processes. The organization might see patterns that one specific manager doesn't, and so they can really kind of drill down into those patterns that are happening at the company. And so connecting those dots in those areas. So if I can talk, documentation isn't about creating liability. It's really just demonstrating that the company responded appropriately and acted in the way that they needed to.
Oh, Sarah, did she freeze? This is why I said I would still do co-host stuff.
Oh no.
We knew this. Sarah's up in Wyoming, and so sometimes Wi-Fi hasn't gotten to Wyoming yet. All right. So I think we were talking through how that lands on a manager. Lindsay, I've been dying to be like, I want to hear what Lindsay says about this. I want to hear what Lindsay says about this. So Lindsay, Sarah tried to join. Will you talk to us about how you elicit this sort of information during an investigative process?
It's so hard, right? Because we're talking about patterns and practices that become sort of normal over time and thus become invisible. And so oftentimes what may be problematic behavior or a lack of addressing concerns becomes considered by employees to be just normal, and that's how things are done here, or that's the way it's always been done. And so oftentimes employees don't know to report those kinds of issues, or when they're asked about it, they don't know they were meant to have been paying attention to it. And so the investigative process means we have to really dig at specific examples of times people did certain things or didn't do certain things, or how people reacted, and whether, gauging their sense of whether or not that behavior or those decisions are normal. And so it really does require an extra level of digging, because there's such a level of kind of unconsciousness or subconsciousness about their observation of those practices.
I'm gonna go off script because that's what I always do to you guys.
Yeah, please.
Lindsay, when you're doing an investigation and you are an outsider coming in and you're like, I don't understand the decision making. This is why I think this is a cat's paw issue here and there. Um, how can you talk to internal investigators, because they're in the weeds. They have the same brain as the entity that's being investigated. How can they check themselves to say, do I have a cat's paw issue? Do I have a remote actor issue here, when they're within the system?
Yeah, it's really tricky, right? Because I think what you were kind of getting at is like internal investigators also often bring such significant institutional knowledge to each issue, as well as like deep history with all the players in the process. And so that's actually why we end up getting involved a lot of times, is because they recognize that they will have a difficult time pulling themselves out of whatever the given situation is. And, sometimes they're implicated because they're the investigator or they're in HR and they just are in a highly exposed position. And so talking through with those clients about, sharing with them that they're wise to like outsource these things when they have the recognition that they're too deep into the dynamics, and talking through with them strategies for being on the lookout for sort of signals that they are making assumptions or that sort of thing based on their institutional knowledge. And so helping them become more objective observers of the situation and acting like they don't know information when they do know information sometimes, because that can be revealing about the kinds of assumptions they're making or what they've already predetermined as a relevant factor if it's not. So guiding those clients through pulling themselves out of the situation.
Yeah. You want to pick it back up, Sarah?
Yeah, and I always enjoy hearing from Lindsay's perspective on certain things. But let's pick it back up with Amber. So when a complaint does happen informally, so like a comment to a manager, a side conversation just with HR, and nothing happens after that informal complaint, what message does that send to the rest of the workforce, and what problems do you see come from that?
Employees watch, they pay attention to what happens around them. They also talk to each other. So if someone speaks up and they just disappear into a black hole, they're going to stop reporting issues, not because the problem ceased, but just because they don't believe anything will change. And that really creates a ton of other problems among, just morale and things like that. So operationally, it becomes a culture problem. Legally, you have credibility when it later claims encourage employees to report concerns. So, a complaint process really can help an organization build trust is overall. So just make sure if there is a concern, you are responding, you are following up, and handling those accordingly.
And then, Lindsay, from a psychological standpoint, how do problematic norms become invisible to the people inside the organization? Why don't people just speak up and say something?
Yeah, I did touch on this a little bit while you were getting your Wi-Fi worked out, but I definitely didn't go into depth. I talked about kind of how even problematic practices become normalized so that employees don't know that they need to pay attention to those things or need to even be concerned about them. But there's a couple of other things that are often going on here. When you work in groups, a lot of times people feel like somebody else will take responsibility for raising the concern or bringing it to the manager's attention or taking it to leadership or HR. It's sort of that classic bystander effect that we probably all learned about in our Psych 101 classes. And so they assume that someone else will take the responsibility. And a little bit related to the kinds of things Amber was talking about is, employees do watch what happens or doesn't happen when concerns are raised. And if it's even worse than nothing changing and they actually see people being penalized or disciplined in close proximity to a complaint or concern they raise, they start to become fearful of raising concerns that those kinds of consequences, a retaliation issue may come up. So, we've got the normalization piece, we've got sort of the diffusion of responsibility piece, we've got fears associated with potential for retaliation. So it's kind of a nasty cocktail for, even problematic practices to persist in organizations.
And it doesn't sound like it would help employee retention either, which is
definitely not. I mean, I didn't even get into all of the cultural. Amber kind of alluded to it, but all the cultural problems, turnover, retention issues that result from those dynamics.
Yeah. And Brian, when an employee does raise a concern, whether that's formally or through an informal process like we've been talking about, and the employer doesn't investigate, doesn't do anything, what legal exposure does that create beyond what was originally complained about?
Sure. And, as an employer, you have a duty to protect your employees. And one of the ways you do that is by investigating complaints. And, you don't have to get to the bottom of it, but you do need to look around. If you fail to investigate a complaint, you're really shooting yourself in the foot culturally, but also legally. The Farragher-Eller affirmative defense is what you're going to lose out on. And basically what that says is that a company who does a reasonable investigation and takes remedial action based on that investigation, they're not responsible for the initial conduct. They're only responsible for the conduct that would come after the investigation you didn't do. So if you don't do the investigation, you lose your opportunity to solve the problem in reality, and you lose a legal defense that would completely absolve you from a legal perspective of being responsible for this discrimination or whatever the underlying conduct is.
Yeah. And from a transactions perspective, I still see the remnants of this normalization problem whenever people are trying to sell, merge with a bigger company, just bring in a private equity partner because they ran into some funding issues, or they just want to diversify that portion of their business. But the new ownership in the due diligence process, oftentimes they do a cultural assessment. They find out what the company's actual operating norms are, and they compare that with the written policies, or they have one of their advisors compare that with your written policies. And when they see that they're essentially dealing with two different companies, one on paper and one in reality, usually it will kill the deal, or at the very least, it's going to be factored into the pricing of the deal. So it's just something that you really need to get ahead on. It will bite you in the butt, even if you don't have formal legal action, or even if you're like, hey, cultural problems, I don't really have time to deal with that now. It's still going to affect you if you want to sell your business and just do something else. So now let's move to let's talk about the evidence that builds up over time without anyone intending to create it. So first, let's go to Amber. Can you walk us through specific informal everyday HR decisions that you've seen accumulate into disparate treatment or disparate impact claims over time? And what does that pattern look like by the time someone actually files a charge?
Sure. Yeah, so very rarely is it one decision that, has a legal issue like we've talked about. So it's a lot of individual decisions that come up that kind of all just really point in the same direction. So, we've talked about different scenarios a little bit. Someone gets a promotion, another gets a better schedule, and it's not, on a defined basis that's applied consistently across the company. So every decision seems reasonable on its own, but then you put it all together and it really looks like there is some impact going on there. So I think someone, whether you have an HR person or not, should be auditing these decisions, should be looking for, are there certain departments experiencing higher turnover? Are performance ratings consistently lower for one group over another in a company? Who's actually receiving promotions and development opportunities? Pay increases, are they being applied consistently? So looking at trends across a company, whoever that looks like in your said company, is so important, just so you can get those early and be proactive rather than reactive.
Right. And Lindsay, is there a difference, and does it matter between a manager making biased decisions consciously or a manager that is making biased decisions but doesn't seem to know that they're doing it?
Yeah, I'm going to give the best possible answer and say it depends. And I might, Brian, step on your toes a little bit here, but what you'll see behaviorally in a difference between a consciously, intentionally biased manager and an unconsciously biased manager is really the behaviors that surround the decision. So a manager who's operating with intentional bias will be able to articulate the actual reason for their decision if they're pressed about it. But you'll also often see evidence of them trying to hide it and create the pretext for that decision. So we talked at our last Acorns about not just the importance of documentation, but the timing of documentation on employment-related decisions. And you're going to find yourself having to defend a manager whose documentation happens after the fact. And so those are sort of breadcrumbs toward an intentionally biased manager. An unconsciously biased manager may be operating on bias, but it's bias they don't understand or have awareness of necessarily. So it manifests itself in sort of what things they notice, how they interpret sort of ambiguous performance, who they decide is a good culture fit. These are all sort of subjective and unconscious determinations that can influence, however, decisions, their employment decisions in a biased way. But the difference is they believe their actual, their stated reason for making the decision with sincerity. And so as an investigator, I can usually suss out the difference, but your question really is, does the difference matter? And it really depends on the claim they're making. If it's a disparate treatment claim, then yes, they have to demonstrate that intent was present. But more often than not, we're looking at disparate impact. And so, so the system process by which the decision was made doesn't matter if the outcome still is discriminatory. And so that's the case in which, intentionality versus intentionality won't matter. And now Natalie wants to correct me on something.
I don't want to correct you. I want to be the lawyer on the investigations team. I just wanted to make the point that there's two recent court. Brian wants to also. I wanted to just point out that courts are saying things about a couple of points that Lindsay made. So courts are saying things about the disparate impact concept, and it's on that issue, it is different than 65 years of history. And so we'll see, and under the next presidential administration, do we go back to the normal interpretation of the way we calculate consequences for employees? And so the point that I would make for people listening today is that today we have a singular case that said, I don't know, maybe disparate impact isn't the right way to do this. It's all academic and whatnot. But we still have 50 states that, in Puerto Rico, some other places too, that have said disparate impact is a thing that we also distribute amongst our statewide interpretations of these things. And if I owned a company, and I do, the way that I would use this information is that I would say, okay, but I can still have the higher standard. I have no idea what the EEOC is going to do under this administration or the next one, but the slightly higher standard is to still acknowledge the 65 years of history that gave us the tool of the disparate impact analysis. And then the other thing I wanted to say just escaped me. Oh, cultural impact. Lindsay touched on, they're not a culture fit. And the thing that has been percolating in the courts that we keep seeing decision after decision. So, right, this is a little bit different situation where courts at state and federal level are over and over and over again saying, hey, employer, we call you out for that not a cultural fit excuse. So we are not at Treaty Oak allowing our employees to use that excuse with us and advice that we're giving them. No, let's dig deeper. What is the real reason that you don't like this person? Culture fit might be it, but we need to be a lot more granular in our articulation of what that means, because just writing on exit paperwork, not a cultural fit, or on EEOC or Workforce Commission paperwork, not a cultural fit. That doesn't count anymore. It's not good enough. Courts have consistently said, we see you and we call you out for that laziness. It's bias. It's probably discriminatory. And since I'm used to being host, I'll say, Brian, what were you going to say?
Yeah, I wasn't incorrect Lindsay at all, but on your point, Natalie, I mean, cultural fit is basically code word for race discrimination is what courts are finding. But I was just going to make the point that Amber and I were working on a case recently, and I'm talking about the owner, like, not knowing about their own bias. We were working on a case recently, and the HR person for the company was trying to bend over backwards and get us to provide extra support for why what the owner wanted to do, they shouldn't do, because the owner didn't recognize their own bias. So it might be this unrecognized bias in the employee that's making a decision, or it could be the owner as well that has a blind spot for a specific employee, and it might have nothing to do with the protected characteristic, but you can bet an employee's attorney is going to call that out if it looks like race or religion or whatever it is, gender discrimination. If that is what the only option they have, they're going to definitely point it out.
And I think when you're comparing intentional bias decision making and the unconscious bias decision making, what seems scarier is the unconscious bias decision making, because you're like, how do we address this?
Right.
Lindsay, do you have any opinions on like what structural changes might actually work to interrupt that unconscious bias decision making pattern that's going on in a lot of workplaces?
Yeah, there's it really goes back to system and structure in organizations. Of course, you can do unconscious bias and awareness training, and the evidence shows that there is some impact in just creating awareness, but that doesn't change behavior. And so organizations are best served when they force behavior change, of course, with all of the great implementation practices they do to make sure that there's buy-in and all of these sorts of things, but that's sort of a separate issue. Whenever you have standard employment decisions that are made by managers in your organization, so things like hiring decisions, performance evaluations, disciplinary decisions, and termination decisions, those are the biggies. Having standard rubrics that define the criteria that are being evaluated in advance of ever making any of those decisions will best serve organizations and set your managers up for some easy documentation, because they'll have a rubric to follow. Secondly, and we see this actually in a lot of our governmental and quasi-governmental organizations that has saved them in some cases, and that is routinely conducting employment decisions in a calibrated way so that multiple parties are involved. No singular person is responsible for making the big employment decisions. And as it relates to those evaluation criteria that we just talked about, getting multiple perspectives on where those evaluations should lie can really be a mitigating factor as it relates to interrupting those unconscious patterns, because they'll be caught if other people, not caught in a sense that like you've done bad, but the bias will sort of come out in the wash when it's on balance with other people's perspectives and also objective criteria that they're meant to follow.
Right. And this is a bit off topic, so I'll just go ahead and open it up to anybody that feels comfortable answering. If you have AI making conscious or unconscious bias decision making, whether it's through hiring, firing, does that matter to the employer? And should you fix it, and how? Brian?
You're not protected because AI made the decision. First of all, your AI transcripts are going to be discoverable if you get sued. And no, the AI is biased because a lot of the time it's an echo chamber for your own opinions. And so thinking that that's going to save you is a huge mistake.
Yeah.
We've always talked about AI for any purpose being considered a thought partner, not a decision maker. It should never replace your own judgment or the judgment of a group of individuals.
And I think there was
Sorry, I would also hope that you have in your AI sort of organizational, like this is such a big topic, right? But that your AI instructions to and for your organization, are private, because again, the evidence thing, like as a law firm, please stop giving your evidence away. But your instructions to every AI is to constantly challenge your bias. In any engagement you have with your own AI, please, please, please have that in your instructions and just generally be aware of it. It is not something Title VII permits you to delegate. You cannot delegate your obligation not to discriminate to a robot. You just can't.
Yeah, Yeah, and the reason this was on my mind because I just read about a case and I'm forgetting the state right now, but then the AI prompt was literally, "Hey, I'd like to fire this person because of protected reason. Help me do that in a way that I can get away with." It was essentially the prompt that was used, and it came back to bite them in the butt, and they acted surprised. So you cannot use AI as a thought partner to help you intentionally make biased decisions and think that it's going to be okay. But yeah,
Well,
AI can.
yeah, that's a good example of intentional bias. And now
Yeah.
there's evidence of it. I think we live in an age now where proving up intent is going to be much easier, actually.
Mm-hmm. And I think there was another case when it was AI was being utilized to help them go through employee applications, and they found out that AI was deciding to discriminate against like certain classes, and you're like, yeah, you still need to own that and check that process and audit it. And it just is a really interesting factor when we get into disparate impact conversations.
Yeah.
And then I know I've been hammering this point for most of this hour, but you really need to get the decision making process and any intentional or unintentional bias that might be going into it cleaned up before you go into any sort of due diligence process. So a lot of times people think, well, worst case scenario, a plaintiff's counsel is going to be analyzing, my compensation anomalies, promotion gaps, personnel records, turnover concentrations, things like that. Those also come up in due diligence, and buyer's counsel does notice. And if they start getting an ick factor once they dive into these records, it will kill your deal. So just you really need to clean up shop.
Sarah, it's not just for sales. Like we work with a lot of small employers, but it's federal audits on state entities, state audits on local munis. It's, I need a loan to grow the business for this way, and the bank will want to know what that's about. It's merging. It's not just buying, it's mergers. It's, transfers to next generation. It's it's awkward, but it falls on operations and HR to go remind the owner who is likely a technician, right? We were talking about Amber and I were talking about this morning with a practitioner who now owns a large organization and is just screwing up the HR because they're so in the genius of building this company. And it is affecting the way they do all of the growth things that they need to do because they've ignored this part that was sort of on the side of their genius, right? It's often outside the genius of the founder or the genius of the leadership, and it gets ignored, but it's such a deal killer.
Yeah. Yeah. And you see this a lot with the tech companies, and a lot of people, one of their default like estate planning instincts is always to like find a mechanism so they can pass this company, which they view as their legacy, down to their children. Like think of the problems that they're going to be inheriting, and that, is whoever you plan on giving the company to prepared to that, can address it. And a lot of times people focus on just building up the tech as building up their legacy. And they're like, well, the people things can just be handled by someone else, and they're more ancillary in the matter. But once you're focused on building up that legacy, it should be part of those conversations, and you should audit it. And yes, it will come up in a lot of situations besides just a buy sell transaction. You're going to need to go to the bank for a loan at some point in your business journey. Like just be proactive so you're not scrambling to clean things up before you really need to get to that point, because closing deadlines are stressful. And so we've covered a lot, the legal doctrines, the behavioral mechanisms, and the patterns that build into exposure. So let's close today with what employers can actually do about it before a complaint lands. So focus on the practical steps. So I'll go ahead and answer the first one myself. So it's just if an employer realizes today, and it might be after they've listened to this talk, that their informal practices have drifted away from the written policies, what should you do? So step one is assess the gap. So compare what your written policies say against what actually happens. and try to find a way to make it match, as long as what's happening is in alliance with good practices and things like that. And then find a way to make sure your policies that you update or stay the same are just implemented. That's the biggest risk mitigation step you can do, because then what to expect, what's going on, nobody's going rogue. Anytime people go rogue, it's hard to predict where things will land. It's a slippery slope. It can always be like, well, this isn't that big of a deal, and the next time you look at it, something extreme has occurred. So just keep that in mind. Step 2 is getting employment counsel involved before you start producing documents, interviewing employees. Like, just focus on building a relationship with an employment counsel. Running a business is a lot, and this is a lot to keep in your head. Like, you're focusing on keeping your business successful, not keeping up to date with legal trends and how disparate impact is being treated. And there's just a lot of moving parts. So focusing on getting that relationship going. And the attorney-client privilege will attach differently depending on how, review is structured. Doing it wrong can turn a proactive self-audit into some discoverable evidence that Brian can tell you more about the problems that come from that.
Sure.
Brian? Yeah.
Thanks, Sarah. If you're doing an audit yourself, that audit is probably not going to be protected under the attorney-client privilege. However, if you hire the law firm to do that audit, then all of a sudden that is not discoverable information. So you can fix the problems that you found without ever having the knowledge of those problems be discoverable. I'll also add that, if you run a AI search yourself, I think someone threw out the example of, how do I don't want to hire this, or I don't want to fire this employee because of their race. How do I do this and get away from it? If your lawyer types that into ChatGPT, that's going to be privileged. But when you do it, it's not. So that's one thing to keep in mind, is the evidence that
Not that a lawyer should do that, right? Lawyers?
Well, I mean, a lawyer wouldn't need to do that because we would think differently. But just to make the point that we have a privileged, protected ability to do these things and to help you walk through them without shooting yourself in the foot, because there's just so many landmines laying around. And additionally, when you discover a problem and you fix it, that provides you with a legal defense by fixing the problem. So I see so many times where an employer was going to terminate an employee, and they didn't. They gave them a bunch of chances by not enforcing a rule, and then all of a sudden they make a protected complaint. Like, let's say, I have ADD and I need this accommodation. Well, you were going to write them up several times and you didn't. And now if you start to write them up, it looks like it's in response to that complaint, when in fact this was a long ongoing problem. So I think that fixing the problems and recognize, in order to fix a problem, you need to recognize you have a problem. And the best way to do that is to engage counsel to help you be a partner and to make that discussion privileged.
Building off of that, Brian, is there any point at which a company's informal practices might be so embedded that fixing them is actually what will create more legal risk than just leaving them alone? Or how do you counsel a client who's afraid that cleaning house will surface something worse?
Yeah, I mean, that's always a difficult place to be in. But the record's already there, and so fixing it isn't going to expose you. It's going to act as your protection for yourself. And I think it doesn't feel that would be safe for many business owners, but in fact that really is the answer.
Yeah. And last question, I'm just going to open up to everyone. So if you had to have just one action item that you think is the most important for employers to take in the next 30 days to reduce the risk we've talked about today, what would you recommend? Amber, you can go ahead and start this one.
Sure. I would say train your managers, train your staff, train them to understand the policies, what to know, recognize signs early before the employee ever brings it to you as a complaint. So I would really start with training.
Brian?
Yeah, I would say document. I mean, ask your managers to write down the criteria they're actually using, like let's say for scheduling, for deciding who gets overtime and who doesn't, because having a written record is your protection. Contemporaneous documentation, like if you make a decision, write down why. Because after the fact, it's too late to do that.
Yeah. Lindsay?
Um, given that today we've talked about how problems remain invisible due to things like normalization and unconscious bias, you can force patterns to reveal themselves by pulling the data. So do a demographic audit. Look at your major hiring decisions by demographics and see if there's any notable patterns that emerge. And if not, great, you're in good shape, right? But otherwise, if you see that women are getting fired at an inordinate pace or not being hired at a rate that you wouldn't expect or what have you, it doesn't say anything about what's causing that, but it will reveal the pattern to you that was otherwise obscured. So do a demographic audit from the last 12 months of major employment decisions. And we do work with a lot of solopreneurs, a lot of small businesses. So it might be that the data, you don't have systems to reveal that data. And so if you don't have the data, build the system that will give you the data in the next 30 days.
What about you, Natalie? I was actually going to pick on you. It was on my list.
I have thought. I think just to echo first Lindsay's last comment, the harvesting of data is so easy now. Like, just do it. You don't have to be Microsoft to have databases of data about your 5 employees. Like, it's so easy to harvest data now. But I was going to say, get you a legal partner that is a partner, not just somebody you go to. Like, hire a firm that tells you things like, I don't need you to give me money to fix that problem. That turns away your work sometimes so that you're comfortable asking little questions. Like, look, it's not a great business model for me to have an employer that sends an email to me that we don't get work out of. But from a philosophical perspective, I refuse to own a law firm that won't tell our clients, you don't need to give us money to solve this problem. You can do this yourself. And it is so much better than somebody not having a legal partner, because I mean, we just have this training in issue spotting and maybe being a bit histrionic about the way things could go and helping you guys back down from that. So, like, how many times, Brian, have you and I said to clients, just email me the thing you just told me on the phone. Just email it to me. I'm not going to do anything with it. I'm going to throw it in a folder in my email and I'm going to save it. And hopefully that email will never see the light of day. I'm not charging you to receive your email. Just email me the good reason you just told me for firing that person. Email me the decision you gave me for demoting, for changing wages, for whatever it is. I just want you to have a chronicle of it, and I'm willing to be your partner in doing that. But yeah, I find somebody who is a sort of profit-minded, team-building, people-oriented legal partner. We're just consultants at the end of the day, but partner that you can bounce ideas off of. Because sometimes people will call and be like, oh, I don't think this is a big deal. And I'm like, stop everything. And sometimes people will call and say, like, I have this big problem. And I'm like, this is why we don't need to talk anymore. Um, so just have a thought partner in your legal specialist, which is not an AI thing. Oh my God, AI is just not good at legal brainstorming yet.
Yeah.
That's my
And
two.
I'd say my one bit of advice is just if you are planning any kind of over ownership change, and this one gets overlooked is like if you adjust membership percentages between existing members, things like that. But if you're planning anything like that, getting an investment or any sort of transactions in the next year, start the conversations with your employee attorney now to review your practices before that deal even starts. Don't wait until after it closes.
And then I opened up the mic to everybody. We are done by time, Sarah. I'm not looking at our schedule, but we're done by time. But it looks like if anybody has any questions with the last minute or two, and we can take them. Hearing none.
Mhm.
Sarah, would you like to close the meeting?
Yeah. Well, if anything from today's session made you want to look more carefully at how your company actually operates, not just what your wonderful handbook says it operates, that's the right instinct. So I work at Treaty Oak Law Group on the business side of employment problems. We work with Texas employers on HR audits, handbook reviews, workplace investigations, and the kind of employment advice that helps you find out you have a problem before it becomes urgent and the EEOC does, or before a buyer's council does. So if you'd like to learn more about what kinds of reviews look like, and go ahead and visit our website, the link's in the comments, and we'd be happy to speak with you. So thank you to Brian, Amber, and Lindsay, and Natalie for all being here today. You can download the checklist in the comments and share this with your HR team or office manager to start a conversation. So we hope to see you all next month. And it looks like Nicole's unmuted. Did you have a question?
Oh, no, I just wanted to say thank you. This was very insightful and a really good one. I liked the information about the not a culture fit.
Mhm.
And that's something that I'm going to spread, make sure our team is aware of.
Yeah.
Yeah, lots of people, once they find what they think are the magic legal buzzwords, it tends to get over abused, and that causes all of us great heartburn.
I'll be happy to watch that one die. So Nicole, thank you for your service.
Oh. Thank you.
All right. Well, I think that Kylan.
Thank you all. Thank you.
Yeah. Well, I'll call that a wrap then. Thank you guys for joining.
Bye, everybody.
Bye, everybody.